Hello everybody, welcome to iExamB's Legal Bee. This is Amrita, your law faculty here at iExamB. So in this video today I'm going to continue with the series that I have started yesterday for the previous year paper of SEBI Grade A Legal Officer Examination. Before we start discussing that, let me tell you that iExamB has an exclusive law channel that is Legal Bee. इसको आप जल्दी से सब्सक्राइब कर लीजिए. कोई भी क्वेरीज हो यू कैन रीच आउट टू अस बाय राइटिंग अस एन ईमेल ऑन hello@iexamb.com. आप हमें कॉल कर सकते हैं ऑन 9205524028 एंड यू कैन ऑल्सो विजिट आवर वेबसाइट www.iexamb.com. You can check out the demo of all the courses that is available on our website. सारे ऑनलाइन कोर्सेज सेबी या वेरियस अदर एग्जामिनेशंस के भी कोर्सेज को आप चेक कर सकते हैं. एंड यू कैन डाउनलोड आवर ऐप फॉर mock tests which are more than 2400. So prepare 50% faster with us at iExamB. In this video today I'm going to discuss with you all the second part of the MCQs for phase 1 paper 2 of the 2023 previous year paper. ये previous year paper memory based paper है जो create किया गया है depending upon the inputs of the students that have appeared for this examination last year. iExamB has been a facilitator in adding so many selections in SEBI. As you can see the numbers reflecting themselves. So if you have a dream of joining SEBI Legal, then you can check out our course that is available at iExamB. These are the details of the course as you can see it over here. Live sessions, notes, descriptive questions and MCQ booklets also are available with video lectures, crisp video lectures, practice tests and interview guidance as well. इसके डिटेल्स भी आप 92055 वाले नंबर पे कॉल करके देख सकते हैं. सो लेट अस स्टार्ट विद द 26th क्वेश्चन ऑफ दिस वीडियो सीरीज. पार्ट 1 में मैंने फर्स्ट 25 क्वेश्चंस कवर किए हैं एंड नाउ आई एम गोइंग टू स्टार्ट विद 26th अप टिल 50th क्वेश्चन. Where the mortgage property is a lease and the mortgagee obtains a renewal of the lease, the mortgagor upon redemption shall. तो ये mortgage से related है. अगर mortgage property को lease किया जाता है, what will be the consequence of that? Not have the benefit of new lease, have the option to terminate the lease, benefit of new lease in the absence of contract to the contrary, have the benefit of new lease despite present contract to the contrary. So the correct answer is D, have benefit of new lease in the absence of a contract to the contrary. Section 64 of Transfer of Property Act deals with this concept. Mortgage and lease. So renewal of mortgaged lease is covered directly under section 64. Goods to be manufactured or produced or acquired by the seller after the making of the contract of sale are called as prospective goods, future goods, retrospective goods, specific goods. काफी conceptual logical question है. If you know it, then within some seconds you can solve it and score well in this. So in these logical and conceptual questions you should be thoroughly prepared with. So the correct answer is B, future goods. Future goods का concept काफ़ी important है Sale of Goods Act में से. I would suggest ऐसे concepts आपको हमेशा ध्यान में रखने चाहिए, MCQs में पूछे जाते हैं. Section 2 Clause 6 of Sale of Goods Act covers this. Future goods means goods to be manufactured or produced or acquired by the seller after making of the contract of sale. A warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to claim for damages, rejecting the goods, treat the contract as repudiated, reconstruction of the contract, create charge or encumbrances. So if warranty is a stipulation, basically it's a condition that is collateral to the main purpose of the contract. So breach of that will give rise to what? Also a question, very important area. Warranties, guarantees, all these are important areas from Sale of Goods. Correct answer is claim for damages. Section 12 of Sale of Goods Act deals with conditions and warranty. Both these concepts are very important. Where there is an unconditional contract for sale of specific goods in a deliverable state, the property in the goods passes to the buyer when the contract is made, when the goods are delivered, when the payment is done, when the time of payment is fixed, when contract is made and goods are delivered. So the correct answer over here, again a question from Sale of Goods Act only. Goods are in a deliverable state. Then the property will pass in the goods. The property in the goods passes to the buyer when the contract is made. Section 20 of the Sale of Goods Act. but specific goods should be in a deliverable state. This is what is the condition. If the parties fail to determine the number of arbitrators, the arbitral tribunal shall consist of sole arbitrator, arbitral tribunal shall consist of 3 arbitrators, tribunal shall consist of 2 arbitrators. The number shall be determined by court. Court will order the parties to decide on the number of arbitrators. Correct answer is A. Arbitral tribunal shall consist of a sole arbitrator. Section 10 provides for the number of arbitrators. Parties are free to determine. Okay. If they fail to determine, then what is the failing determination? In clause 1, the arbitral tribunal shall consist of a sole arbitrator. If the parties fail to agree on the place of arbitration, ये टाइम, प्लेस, नंबर, ऐसे रिलेटेड क्वेश्चंस भी काफ़ी सिंपल क्वेश्चंस होते हैं जो आर्बिट्रेशन से डायरेक्टली पूछे जाते हैं. प्लेस ऑफ आर्बिट्रेशन शैल बी डिटरमाइंड बाय कोर्ट, ट्रिब्यूनल, by arbitral tribunal having regard to circumstance of the case. Place of sitting of high court by determined by the parties is directed by the tribunal. Correct answer is C. Section 20 covers this concept of place of arbitration. Parties are free to agree on the place of arbitration, but if they fail to agree, the place of arbitration shall be determined by arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. The arbitral tribunal shall issue an order for the termination of arbitral proceedings where the arbitral tribunal finds that the continuation of the proceedings has for any reason become unnecessary, arbitral award has been passed, arbitral proceedings have prolonged, award cannot be passed, dispute has been rejected. So termination of arbitral proceedings, if you go through entire concept, you can very easily answer this question. Correct answer is A. Arbitral tribunal finds that the continuation of the proceedings has for any reason become unnecessary. So this is one of the valid condition. Section 32 deals with the concept of termination of proceedings. So इसमें से आपको कोई भी कंडीशन यहाँ पे पूछी जा सकती है, तो ये सारे कंडीशंस आपको पता होनी चाहिए. ये क्लॉज नंबर C वहाँ पे ए ऑप्शन में कवर्ड था. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal, invitation to offer, promise, conditional promise, contract. So when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining consent of that other to such act or abstinence, he is said to make what? In contract, you will find such kind of questions. These are actually very common questions and very again conceptual questions. ये questions होते तो बहुत easy हैं, but कई बार क्या होता है, अगर conceptual clarity नहीं है तो हम लोग थोड़ा सा confuse हो जाते हैं. That should not happen. Be very clear with your conceptual clarity. Correct answer is A, proposal. Section 2A of the Indian Contract Act talks about proposal. Willingness is very important element over there. An agreement which is dash is a voidable contract. Enforceable by law at the option of one or more other parties. Enforceable by law at the option of one or more parties, but not at the option of the other. Not enforceable by law. Not enforceable by law at the option of one or more parties. Enforceable by law. So an agreement which is dash is a voidable contract. Correct answer is B. Enforceable by law at the option of one or more parties, but not at the option of the other. Section 2I of the Indian Contract Act deals with agreement which is enforceable by law at the option of one or more parties, but not at the option of the other or others, is a voidable contract. Contingent contracts to do or not to do anything if an uncertain future event does not happen. Be very careful when you read the questions also. Sometimes, as I told you, the question is easy, the concept is easy, but the question we don't read it properly, or we read the options, we get confused. So that thing should not happen, as negative marking is also there in SEBI examination. So be very vigilant when you read the question as well. Cannot be enforced, can be enforced when the happening of that event becomes impossible, can be enforced on the happening of that event. Cannot be enforced by law unless and until that event has happened. but that uncertain future event does not happen. So the correct answer over here will be C, can be enforced when the happening of that event becomes impossible. Section 33 of the Indian Contract Act deals with this. Where a person gives a guarantee upon a contract that the creditor shall not act upon it until another person has joined in it as a co-surety, the contract is void, guarantee is not valid. Guarantee is not valid if that other person does not join. Guarantee is abolished. Surety is discharged. Correct answer over here is C. Guarantee is not valid if that other person does not join. So where a person gives a guarantee upon a contract that the creditor shall not act upon it until another person has joined in it as a co-surety, then the correct answer will be that the guarantee is not valid if that other person does not join. Section 144 of the Indian Contract Act deals with this concept. Specific Relief Act now. Specific Relief Act से भी questions आते हैं. Specific Relief Act can be granted for the purpose of enforcing penal laws, enforcing individual civil rights, recovery of possession of movable property, recovery of possession of immovable property, recovery of possession of property. Recovery or possession of property. This should be property, okay? Ignore the spelling mistake over here. So the correct answer here will be B, enforcing individual civil rights. Section 4 of Specific Relief Act deals with this concept, that it can be granted for the purpose of enforcing individual civil rights and not for the mere purpose of enforcing a penal law. Suit for recovery of possession of immovable property. If a person is dispossessed without his consent otherwise than in due course of law, can be initiated within 12 months from the date of dispossession, within 6 months from the date of dispossession, within 2 years from the date of dispossession, within 3 years from the date of dispossession, within 12 years from the date of dispossession. This is also an important concept, very landmark one. यहाँ से कई बार questions पूछे जाते हैं and आपको ये भी याद रखना है कि it is from the date of dispossession. अभी options में ये same दिया हुआ है from the date of dispossession, सिर्फ period change किया है, time period. But ऐसा हो सकता है that they may give you somewhere date of dispossession and somewhere they may omit it. Correct answer over here is within 6 months from the date of dispossession. Section 6 of Specific Relief Act deals with this concept. Suit filed under provisions of Specific Relief Act shall be disposed of by the court within a period of 12 months from the date of service of summons to the defendant, 6 months from date of service of summons to the defendant, 12 months from the date of complaint filed by the plaintiff, 6 months from the date of initiation of suit, 12 months from the date of initiation of suit. Now you have to be very careful. Time period as well as from when that is going to start. Correct answer is A, within a period of 12 months from the date of service of summons to the defendant. Section 20C of Specific Relief Act deals with expeditious disposal of suits. Partnership at will is a partnership where time period is specified, which is made with the consent of parties, which can be determined at will, where no provision is made for the duration of partnership or for determination of partnership, which is transferable by will. So partnership at will is a partnership. It is a type of partnership. We all know that. All the types of partnerships should be clear to you, the concepts and the peculiar feature of that kind of partnership. So partnership at will, what is the peculiar feature over here? D, where no provision is made for the duration of partnership or for determination of partnership. Section 7 deals with the concept of partnership at will. A enters into a partnership with B and C to undertake a contract of construction of a building and divide the profits equally among them. This is partnership at will, particular partnership, not a partnership, temporary contract, partnership by status. So in this condition, what kind of partnership it is? Answer is B, particular partnership. Kinds of partnership से दोनों भी questions आए हैं. एक partnership at will followed by this question. This is relating to the next type, particular partnership. Section 8 deals with this concept. person may become a partner with another person in particular adventures or undertakings. So वो partnership restricted होती है only for that particular type of activity that has been undertaken, nothing else is taken up. A minor may be admitted to the benefits of partnership. Minor partner भी काफ़ी important concept है partnership topic से, that also you have to be very clear with. With the consent of majority of the partners, he can be admitted. With consent of all the partners, without the consent of all the partners, he can be admitted. With the orders of the court, he can be admitted. He cannot be admitted to the benefits of the partnership. Now see, minor partners related confusion हो सकता है. You have to be very clear with the concept that minor का actually status क्या होता है partnership. He may be admitted to the benefits of partnership. Answer is B, with the consent of all the partners. Section 30 of Indian Partnership Act deals with minors admitted to the benefits of partnership. Person who is a minor according to law to which he is subject may not be a partner in a firm, but with the consent of all the partners for the time being, he may be admitted to the benefits of partnership. He will not be a partner, he will not have any liability as such, personal in nature, but he will be admitted to the benefits of the partnership. उसका जो शेयर है उसमें से liability exercise हो सकती है, no doubt in that. Whereby the wrongful act or omission of a partner acting in the ordinary course of the business of a firm, loss or injuries caused to any third party, the firm is not liable. Other partners may remove the wrongdoers from partnership. Firm is liable to the same extent as the partner. All the partners are liable. The partnership is terminated. So by a wrongful act or omission of a partner who is acting in the ordinary course of business of a firm, loss or injuries caused to any other party at that time, what will happen? Correct answer is C. Firm is liable to the same extent as the partner. Section 26 of Indian Partnership Act deals with this concept, liability of the firm for wrongful acts of a partner. Subordinate legislation is when Parliament makes procedures to operate itself, Parliament makes laws for working of executive, Parliament delegates law-making powers to the executive, Parliament does not delegate law-making power, Parliament makes law to regulate the country. So what is subordinate legislation? In all these options you have to answer. Don't have to get confused with what is this concept. In this particular question, looking at the options, you have to answer this question. Correct answer is C. Parliament delegates law-making powers to the executive. We all are aware about administrative law. We are aware of the laws that are made by the executive, because chiefly the law-making function is of the Parliament. Executives are here to implement. But when they make the law, that is coming under the category of delegated legislation. That is coming under the category of subordinate legislation. Primary is always being made by the Parliament. A statute which governs the event which takes place in future after the statute has come into existence is enabling statute, disabling statute, retrospective statute, prospective statute, future statute. A statute which governs the event which takes place in future after the statute has come into existence. So that statute is known as D, prospective statute, that it can be applied only from a future date. आप उसको पीछे apply नहीं कर सकते. You cannot apply it in a retrospective manner. A residing in Delhi publishes in Calcutta statements that are defamatory of B, who is residing in Mumbai. B may sue A only in Delhi, only in Mumbai, either in Mumbai or in Calcutta, either in Delhi or in Calcutta, only in Calcutta. Which is the correct option over here? Relating to defamation. B, either in Delhi or in Calcutta. Section 19 of CPC talks about suits for compensation for wrongs to person or movables. So whenever you are filing a suit for compensation for wrong done, can be to a person and to a movable property. So इसमें defamation भी covered है. So it will be carried out in the places where the person resides, defendant resides basically, or carries on business or personally works for gain within the local limits of that jurisdiction. Whichever court is there the suit will be initiated. This is something which has been picked from the illustrations. कई बार illustration से directly questions pick किए जाते हैं. You can find this illustration over here in section 19 of CPC. Every suit shall be instituted by presenting plaint and duplicate to the court or such officer as it appoints in this behalf. Plaint to the court or such officer as it appoints in this behalf. Plaint to the court. Plaint and duplicate to the court. Presenting plaint to the court and the defendant. So how a suit is instituted? CPC में ये direct provision है. Order 4 Rule 1 talks about suit to be commenced by plaint. And institution of suit भी अगर आप पढ़ेंगे section 26 वो भी यही cover करता है. So presentation of plaint is the first step which starts which institutes a suit into the court, and that should be in duplicate. This is what is the more specific answer. As per Order 7 Rule 11 of CPC, what happens when cause of action is not disclosed by the plaint? अब यहाँ पे आपको order दिया हुआ है, but ये order इतना common है कि आपके ये फिंगर टिप्स पे होना चाहिए कि ये कौन से कंसेप्ट से डील करता है. 711, दिस इज डीलिंग विद रिजेक्शन ऑफ प्लेंट. दिस इज अ कंडीशन. अगर कॉज ऑफ एक्शन डिस्क्लोज नहीं होता है, इट इज वन ऑफ द कंडीशन ऑन विच द कोर्ट कैन रिजेक्ट द प्लेंट. ऑल दीज आर द conditions on which a plaint can be rejected. When a counterclaim is set up in a suit, what happens to the counterclaim if the suit is dismissed? Counterclaim will also be dismissed. Counterclaim can be proceeded with. New suit can be presented for a counterclaim. Court directs the counterclaim to be freshly instituted. Counterclaim is stayed. So in a situation when the counterclaim is set up in a suit, what will happen to the counterclaim if the suit is dismissed? So in that case, what will be the result on counterclaim? Correct answer is B. Counterclaim can be proceeded with. Order 8 Rule 6D deals with the concept effect of discontinuance of suit. Counterclaim may nevertheless be proceeded with. Means you cannot proceed with counterclaim if the suit itself is discontinued. Counterclaim can be proceeded. Counterclaim can be proceeded even if the suit gets discontinued. So correct answer is B. Last question for today's discussion. This is completing the first phase of paper 2 for SEBI grade A legal previous year paper 2023. A person B acts in an intentional or negligent way that causes an unauthorized interference with C's possession or enjoyment of chattel. Which of the following offence has been committed by B? Tort of trespass, tort of negligence, assault, annoyance, tort of vicarious liability. So which of the following offence has been committed? You have to determine over here. Whenever you are determining any offence, you have to be very clear with the ingredients. That is also something which is very important. So the correct answer over here is A, tort of trespass. Generally, a trespass refers to a wrongful use of another person's property without his or her permission. Under intentional torts, there are two types of trespass: trespass to chattels and trespass to land. So this is the description. Tort of trespass has been committed over here. Okay, so let us end today's video. This is the second part, as I told you, of the previous year paper 2023. 50 MCQs of the first phase we have discussed. कोई भी queries हो, do reach out to us. You can also write to us in the comment section of this video. And don't forget to subscribe to Legal B. Stay tuned. Prepare 50% faster with us at iExam.